Hello, welcome to You and the Law, the program that helps you understand your rights and responsibilities under Gambian law. Today we look at one of the most important foundations of justice, the relationship between a client and their lawyer. What should you expect from your lawyer? What do lawyers owe their clients? And what responsibilities do clients have in turn? To help us unpack this, I'm joined by the legal practitioner, Aji Amisise. Hello, Aji. Welcome to the program.
Thank you, Mr. Mboch. Thank you for having me. Today, as you rightly said, we're here to talk about one of the most important parts of access to justice, which is the lawyer-client relationship.
Absolutely. What does it mean in practical terms?
Good question. To start, I would first like to say that the lawyer-client relationship is a relationship that is built on trust, transparency, and honesty, especially from the part of the lawyer. When a client speaks to their lawyer, the client should know that communication is privileged under legal privilege, and clients should be comfortable to disclose information that is pertinent to their case to lawyers, and that comfort should come from the fact that communication is privileged under legal advice privilege and litigation privilege.
But I want to, just before you go on, when does this relationship, when does it begin?
Okay.
At consultation, payment, signing of documents, where does it begin?
Yeah. So typically, it would begin when a client first makes contact with their lawyer. If you operate a law firm, typically you would maybe get an email with a client requesting to have a meeting with you or a consultation, following which you would invite them to your office, and then they would be required to pay a consultation fee. And then you would then have a meeting where you listen to the client and then give advice at a later stage on maybe matters that they've shared with you in which they need advice and guidance. But then that is essentially the start. And to govern the relationship, the lawyer would be required to provide a retainer agreement if they agree to take on the case, or an engagement letter, which would set out the scope of the services they would offer the client, which would then also, where fees would also be determined. Very important for clients to know at the outset what the fee arrangements would be, whether they're required to pay upfront, whether they're required to pay after the required service has been delivered by the lawyer. And at that stage, very important as well, Mr. Mboj, is for lawyers to categorize the fees so that clients know what the lawyer is entitled to in respect of fees, and what costs and disbursements will be made on behalf of clients. I think it's important because sometimes there's an expectation that I pay my client $5, very low. Yeah. Nobody pays their lawyer $5, by the way. And from that $5, it's important to segregate what goes to the lawyer and what fees the lawyer is required to pay on behalf of the client. It could be, for example, to register documents on their behalf. It could be, for example, to notarize documents on their behalf, or to courier and send documents internationally, for example. But it's important at the very early stage for a lawyer to categorize these fees, and for a client to be comfortable to know that from this agreement, this is a fixed fee, or this is an hourly fee, or it's a fee that's based on a contingency. But it's important at the onset.
They agree on terms.
Agree on terms. Fees are one of the most important. Yeah.
Absolutely. Yeah. You've touched on the rights of the client. Yes. Once we've agreed on terms and the like, what are my rights, and in the case that they're breached, where can I go?
Okay. All right. So at the outset, I'd like to first say that a lawyer has ethical duties towards the client, and there's also oversight from the General Legal Counsel, of the Gambia, and a lawyer is expected to act competently, diligently, and in the client's best interest. So as you've pointed out, in return, the client should feel empowered to ask questions. That's number one. Ask as many questions as you want. Require as much information as you need to know. Obviously, an understanding of the fees, like I touched on, and to be involved in decision making as much as possible. There's a lot of legal theorists out there who would talk about what the client-lawyer relationship should be. Some propose that it should be paternalistic, where the lawyer takes the lead in decision-making, in guiding the client. However, on the other side, you have other theorists like Boone, Levin, who propose that no, the client should be part of the decision-making as much as possible, because autonomy should be maintained, because at the end of the day, it's not the lawyer's case, it's your case. So in that approach, where you avoid the lawyer dominating or the client dominating, you would have situations where the client feels a part of the decision making. So in the event that something goes wrong, the client should know that they're empowered to report issues of misconduct, issues of wrongdoing to the General Legal Counsel. The General Legal Counsel is a body that is headed by the Chief Justice of the Gambia. They can be written to with complaints set out and documentary evidence attached, which is why it's important at the very outset to have an engagement letter that sets out what you should expect from your lawyer. So when a report to the General Legal Counsel is made, you can attach the engagement letter and state what your expectations were at the beginning of the arrangement and how you believe they have been breached. So the General Legal Counsel is the body that oversees issues of misconduct, issues of admissions to the bar, and they would be the right body to report issues of misconduct too.
That's it. So where I suspect wrongdoing or mishandling or incompetence, I can go to the General Legal Counsel as a client.
Absolutely, you can.
Yes,
Yeah.
but on this debate, I think it is important. This paternalism and the other one, the client-led,
Yeah.
if you like.
Yeah.
Where do you stand personally on this?
I stand, it's very difficult to answer when you ask a lawyer, do you stand on something?
Yes.
I think a more balanced approach is where we're headed, because naturally you have to remember that the case is not your case, it's the client's case. And at the end of the day, you're acting in the best interest of your client. And sometimes what you can consider the best interest of the client could differ, but your role is to give advice and then allow the client to think about the advice, and if they even want, seek independent advice and then decide on what to do. So I lean very heavily on a very balanced, a partnership sort of approach where a client feels empowered to ask questions, to be informed, and the lawyer retains the right to give advice on the issues, and then allow the client to decide what approach they want.
Absolutely.
Yeah.
So that really means that sometimes you apply paternalism, other times you apply client-led, depending on the situation, isn't it? Especially if one puts it in the context of in our society, most people are uneducated, they probably need help in so many different areas.
Exactly.
Right?
Exactly.
Granted.
That is correct.
So now with the retainer, what do I look for before I sign a retainer?
Okay.
As a lawyer, what are the signs that I should be watchful of?
As a client.
As a client.
I believe not all relationships, not all lawyer-client relationships begin with a retainer. Sometimes there are situations where, due to the urgency of the matter, the client calls and they need you to act immediately. So you wouldn't have the opportunity of preparing a retainer prior to acting, but you can explain to the client generally what services you would offer them, and in the circumstance, what possible outcomes or timelines and things like that. And once there's an agreement, then you can put them in writing. So at first, the scope of work. The client needs to review the scope of work and confirm that that is exactly what they're seeking. Once the scope of work is confirmed, the next segment would be the fee arrangements. Is it a fixed fee? Are you required to make the payment before the lawyer begins working, or are you making payments by installments? When would the payments fall due? Would you be issued invoices before? Would you be issued invoices after? After the fees, you should then look at, there's a final portion of the engagement letter where the lawyer would give a limitation of liability, so that the client understands that advice giving in that particular matter should not be applied to other matters, because the advice is specific and it's related to this matter only and can be relied on by the client only in respect of that matter. So it is important for that to be stated, because, for example, if you approach a lawyer and seek advice on a particular subject matter, and a few maybe months later, a cousin or someone you know finds themselves in a similar situation, and you decide to apply the advice that your lawyer had given you in a previous matter to that matter, the outcomes would be different. So it's important to be specific, so that at the very beginning, the client can kind of know where the matter would lead to and what possible outcomes there could be.
Yes.
So those things, I believe, are very important.
Yeah, I like that example. You should be giving more of these examples. So now, imagine a conflict between client and lawyer. You said then the client will go to the general legal counsel. So is it that body that's going to settle the dispute? And what if I disagree with their decision? Do I have recourse to any other instrument of law?
Yeah, that's a good question. So I first want to say that other lawyers also have a duty to report criminal activity suspected or confirmed by them. I mean, that they know of, that other legal practitioners are doing or engaging, and they have a duty to report. Other lawyers do. It's an important thing to state. For clients, yes, the General Legal Counsel is the oversight, and you would write to them, maybe issue, as I mentioned earlier, evidence, anything that you have, you can take to them. And then the General Legal Counsel could either mediate the matter, and possible outcomes could be the lawyer could be suspended from practice, depending on the degree of the wrongdoing. Apart from that, the lawyer could be disbarred, for really serious offenses. And if a client is dissatisfied, then an appeal can be filed, I believe, to the Court of Appeal of the Gambia for the matter to be revisited. Yes. And then the Court of Appeal can give a direction. The matter could go back to the GLC for final determination. But generally, that is it. Also, clients could also sue lawyers. That is possible for professional negligence. Obviously, in my reading, I came across this quote that says, "Only the brave would sue a lawyer."
Yeah.
But where there is evidence of negligence or wrongdoing, civil proceedings can be commenced against the lawyer. As the old saying goes, no one is above the law. And the lawyer-client relationship is so sacred that lawyers should have the confidence to say whatever they want to their lawyers in the knowledge that the lawyer will not disclose that information. And communications, as I mentioned earlier, are privileged. So even a court, for example, can't compel disclosure from a lawyer unless in exceptional circumstances where the lawyer, for example, knows that the client is about to commit a crime, or in the public interest, for example, if I knew that my client is about to commit some criminal activity that would affect, people, then under situations like that, privilege can be bypassed. But otherwise, clients should be confident that information that they share with their lawyers would be kept confidential.
You always have exceptions, don't you? Now I wonder, are there sort of common complaints that clients make against their lawyers? Have we identified any pattern? I wonder.
Well, it's hard to answer, but I do want to say that in some cases, transparency, sometimes clients should, maybe from the very outset, state their expectations to the lawyer. And then if the lawyer falls short of those expectations, maybe then you can hold them accountable. But I feel that in this era, for example, sometimes you have clients who, from the point of the retainership, they believe that they're entitled to call outside working hours, within working hours, WhatsApp messages, voice notes, asking a myriad of questions on a subject just because they believe I have a retainer agreement, with so and so lawyer, and therefore they should be available to answer as many questions as I have. That is not fair, I believe, should be stated. From the outset, from the retainer, I think if it's important to the client, then they should point out that, I would require updates, weekly, bi-weekly updates, monthly updates on my matter, just so that I don't have to keep putting you under undue pressure. So that expectation should be there. I know that a common complaint is, I'm calling my lawyer and they're not answering, they're ignoring my calls and I've already paid them. But because at the very onset, at the very beginning of the relationship, your expectations have not been spelt out, and on the other hand, the client the lawyer has other clients, and he has to balance the interests of all clients. He has to divide resources, to suit the needs of all the clients. He has to maybe attend court, situations arise. So I believe, at the very core of the relationship, there should be respect, there should be transparency, and clients should be informed. Yeah.
Absolutely. The scenario you've just depicted, absolutely unfair. Now listen to the other side. I do hear clients say stuff like, this lawyer, he's always absent.
Yeah.
Whenever they're scheduled, for some reason he wouldn't be there. You know what I mean? Then perhaps you resort to harassing them, calling them all the time, sending them emails. So what do you say about that? When a client finds him or herself in a situation, what do you do?
Okay, fair question. And I say it's fair for a client to feel entitled to information from their lawyer, should they maybe be in a situation where they find that they have to adjourn a matter or they have to push back a meeting because something else has come up. Because the nature of the client-lawyer relationship is such that a lot of trust, because people come to lawyers at their most vulnerable in some cases, and they come to them seeking matters of maybe great financial importance to them, or sometimes the client's life or liberty is at risk. So we should be entitled to information. If a lawyer has adjourned a matter, you should want to know. However, I believe there should be a balance. write to your lawyer, document communications with lawyers. In this day and age, WhatsApp has now become a medium where people feel I can call at any time, I can send a voice note at any time. I dare say it's not a formal way of communicating. Send an old email, maybe send a text, schedule a meeting, meet the client, meet the lawyer, voice out concerns, and then have it penned down in writing so that you can have your file and evidence that on a particular day, I made so and so complaint to my lawyer, and they failed to maybe fix, or they failed to reach a solution. But those expectations should be there just because of the nature of the relationship.
So that's it. So it is better really in the beginning to spell out really the do's and don'ts, as it were, generally.
Exactly.
And then you sort of movement. Okay. Now, the penalties for professional breaches. And if you can draw from real life examples. So when, for instance, the legal counsel has found somebody in breach or whatever, what happens?
I don't think I'm aware of any recently, to be quite honest, of any lawyers found or suspended from practice. But all of those are possible outcomes from a complaint that is made to the General Legal Counsel. I know that people are interested.
Wouldn't that is slightly suspect? That maybe the legal counsel is behaving more like a union for the lawyers than an independent, autonomous, as it were, adjudicating body.
I feel like it's very difficult to reach a conclusion like that, because we're also not in a position to know how many complaints there are, for example, before the General Legal Counsel. We're also not privy to knowledge of, how many people have maybe written to them and are awaiting outcomes, So I believe maybe with research and data, maybe such conclusions could be looked at and maybe reached if it's fair. But I'm not aware of any. I mean, I feel like clients are free to choose, it goes back to choice, which lawyer you want to represent you in court.
Yes. But I wonder what sanctions exist.
Okay.
What, the legal counsel, what it can do if in the case that somebody's found guilty, if you like.
Yeah. It can suspend the person from practice. And because, our profession is regulated, so we're licensed to practice. So where you're found, to have done something improper or something that would maybe bring disrepute to the profession, in some instances, I'd give examples where, in the Legal Practitioners Act, it prescribes that lawyers should keep clients' accounts separate from their accounts. And you shouldn't put yourself in a position where your needs compete with those of your clients.
Conflict of interest.
Conflict of interest. It's a big area. So where your needs conflict with, that of a client, absolutely, where you should withdraw from the transaction. That would be the general advice. But of course, conflict is more complex than we think. It's thrown around a lot, conflict of interest. But it's important for people to really know what it means and what it entails. But of course, an example is that the person would be disbarred, permanently prevented from ever practicing law again. The General Legal Counsel can impose fines in some situations. There's a whole range of remedies available.
And I suppose it
just depends on the wrongdoing.
Yes, perhaps in even certain extreme situations, they might refer the matter to the police. There could be criminal elements involved, that sort of thing.
Really just depends on the
situation. Granted. But I wonder though, if you were to push for any kind of reform to make it easier for clients to hold their lawyers accountable, what might that be?
Reforms. Well, I think, firstly, programs like this are important because I believe not a lot of clients know that we even have a body, we even have a council that kind of provides this oversight, over lawyers and our activities, So I believe we have a council. People should be aware of their rights, and they should be aware of what mechanisms are there when a lawyer has acted in breach of maybe the terms of the retainer agreement to begin with. But in terms of really reform, it would be more on the other side, which is for clients to be aware, more advocacy maybe perhaps from the bar, for clients to be aware of what avenues there are and what possibilities are there, to hold lawyers accountable.
That's it.
Yeah.
You've probably touched on it, but we've come really to the end. So if you were to give just one advice, both to clients and lawyers, of how to maintain a healthy professional relationship.
Yeah. Thank you, Mr. Moj. So I would like to say, at the end of the day, legal representation is not just about the law. It's about people. If you're working with a lawyer, ask questions, stay informed, and know that your voice matters in every decision. I believe some of the misconceptions there are, at the very basis of it is just some clients feel intimidated by the presence of a lawyer, and sometimes they don't feel comfortable asking, but it's your right. They're there for you. And the other is for clients to be honest with their lawyers. We cannot defend what we do not know. So every single detail about your case, whether you think it's in your favor or not, you're under a duty to share it with the lawyer. If you're a lawyer, remember that clients place enormous trust in us, and we owe them honesty, confidentiality, and respect. And if you ever feel something isn't right, like I said, the General Legal Counsel provides clear and fair process for guidance or complaints. So I encourage both lawyers and clients to build a legal system where transparency, respect, and honesty are the standard. That's what justice is about at the end of the day.
Thank you very much. What a fantastic endpoint there. You've been a fantastic guest. And thank you very much to our viewers for tuning into You and the Law. So join us next time when we'll continue to demystify the laws that shape our daily lives. I'm Until next time, goodbye.